Welcome back to the Law and Crime Network. I'm Heather Hansen. We are on our lunch break in the Donald Smith case, and we are fortunate to have one of our favorite guests on with us this afternoon. Andell Brown is here with me. He is a criminal defense attorney who has been following this case with us. So happy to have you here during this break, Andell.
Always a pleasure, Heather.
We just saw the defense attorney's opening statement, and we know, those of you who have been watching this trial know, that she made a promise that she didn't keep. That's one of the main things that we attorneys try not to do, isn't it, Andell?
Absolutely. I mean, unless you're absolutely sure you're going to be able to keep the promise, you just don't make it at all.
Yeah, and it seems as though, I'm sure she really thought she was going to be cross-examining the mother. She got up there, and, you know, Kathy Russin, our trial producer, pointed out it's like she blamed the mother for taking the child to Walmart. But she did. She blamed the mother and talked about the cross-examination that she was going to be doing of the mother, and then never cross-examined the mother. And that was because her client told her not to. What do you do? Well, first of all, I guess the first question is, have you ever had that situation where your client changed the strategy mid-trial? And if so, what do you do in that situation?
Well, I mean, trial is always unpredictable, Heather, and I've been in situations where your defense strategy changes. Sometimes it's based on the client, whether they will or they won't testify. Sometimes it's based on the evidence that's been elicited at trial. Here, it looks like Donald Smith decided that he did not want to have the mother cross-examined, and it was quite a surprise to his attorney, who had promised the jury that she was going to get into a cross-examination with her.
Yeah, it's I've never seen anything like it because it was so soon thereafter. You know, sometimes if you've got a week between the opening and when the event happens, some of that may have faded away from the jury's memory, and that might not be as striking as a difference between what you've promised and what you've given. But when it's that close in time, it's pretty darn clear to the jury. What do you think this defense attorney is trying to do here? And then I want to ask you what you would do.
Oh, just my luck to be given this case, right?
Right.
Well, I think the defense attorney, what she is trying to do, and the other defense counsel, they're trying to make sure that they can avoid the death penalty here. I don't think there's a path to a not guilty based on the overwhelming evidence of guilt. I mean, you have DNA, you have the circumstantial evidence, you have them on camera, you have statements. The prosecution has everything they need to secure a conviction. The question that I think that's going to have to be answered by the jury is whether or not these crimes warrant the death penalty. And I think that's what his defense attorneys are already looking forward to, making sure that they hold the prosecution to their burden on this level, of course, but with an eye towards avoiding the death penalty when they get to the sentencing stage.
I agree with you, and I think that that is a smart strategy, but then I wonder at the cross-examination. We've seen other cases here where the defense attorneys don't cross-examine anyone because they're just waiting for the death penalty phase, and they don't want to alienate a single member of the jury. By opening and saying we plan to cross-examine the mother and we plan to do it hard, and then by cross-examining people like that yesterday, and we'll play some clips of this again today, but yesterday she cross-examined some of the people who witnessed Donald Smith driving away from the parking lot. And then today there was cross-examination of the DNA expert about the amount of DNA found. How do you think that plays into avoiding the death penalty when we get to that phase? If we get to that phase, I guess, although I don't think that's a big if at this point.
Well, you know, as defense attorneys, you have your strategy, you have your plans, but the most important thing is your client and their rights. And they have the right to make decisions about what you're going to do in their trial. You can, of course, advise them, but they have the final say in a few things. I think what we're seeing here is a disconnect between Donald Smith and his attorneys about how they're going to proceed in this trial. It sounds like the attorney has one idea of what they're going to be doing, and they're getting pushback or resistance or a change of course from Donald Smith about what's happening as the trial is actually going on. And I think that's going to make the jury probably confused and feel as if he is further manipulating and trying to control this situation in the same way that he manipulated and tried to control Rain Periwinkle and what ultimately happened to Cherish.
I could not agree with you more, and I think that was extremely well said, Andell, because that he clearly thinks that he is smarter than everyone in that courtroom, and he is manipulative, he is cunning. We know that he has done things prior to this incident with Cherish Periwinkle where he has pretended to be a family worker, a family governmental worker in order to try and lure in young children. He is definitely manipulative, and you see that here, and I do think it's going to work against him with regard to the death penalty. It's been a very heavy day, Andell, and we're going to go back, and during this lunch break I am going to replay some of the medical examiner's testimony because I know that it's important as we go forward today. But I want to lighten it a little bit because one of the things that happened yesterday that I'd like to talk to you about is one of the witnesses, a lay witness, someone who spoke to Donald Smith briefly in the parking lot, was asked to identify Donald Smith in the courtroom. And I want to play the clip where she identifies him and then talk to you about lay witnesses and how they sometimes present on the stand. So let's go to 28 and see the clip of this particular lay witness who is testifying about her interaction with Donald Smith. And I specifically thought that the identification was something that sometimes we see in courtrooms, though less so here at Law and Crime. So let's watch that clip real quick, and then Andell and I will discuss.
Eventually, did you make your purchases?
At the front of the store, yes, sir.
That evening, did you buy a lot of milk using the assistance?
About 4.5 gallons, I think it was.
Could you and your family use that much milk before it would go bad?
No, we already had some in the freezer.
So did you make some arrangements to meet up with your father that evening so he could take some of the milk that you had purchased?
Yes, sir. I didn't want it to go to waste.
So after you made your purchases, did you and your husband and your daughter wait in the parking lot for your father to arrive?
We had made arrangements to meet right there next to the garden center, yes, sir.
Was your father working that evening?
He was.
Were you driving that night?
Yes, sir.
What type of car were you driving?
It was a gold Toyota Corolla.
And when you pulled up next to the garden center to wait for your father, where did you position your car in the parking lot?
Okay, you would have the store, and then you would have where you would have the main access road was here. So instead of pulling into a regular parking space, we actually pulled alongside of the curb right next to the other entrance so we could see the oncoming traffic.
Okay. Was your side closest to the curb?
Yes.
The driver's side of the car. Was your daughter in the back seat?
Yes, she loves to listen to the radio.
And then your ex-husband, Chris, was he in the passenger seat?
Right.
Was he seated closest to the lane of traffic if somebody would have pulled up beside your vehicle?
Yes.
At some point in time while you were waiting for your father, did a white van pull up next to your car?
With stripes on the side, yes, sir.
And did the driver of that white van make any statements or comments to you?
Yes, he did.
What did he say?
We're going for cheeseburgers.
Could you hear that from where you were seated in the car?
Very clearly. It was very deliberate and pronounced, and I was like, why? I was very confused.
Did you see the person?
Yes, sir.
Describe him for me.
Wearing a black or dark colored t-shirt, had some kind of something on the front, I couldn't tell. He had his left arm out of the window and one hand up on the steering wheel. As far as facial, it was white hair, kind of maybe like a sandy white color, had a mustache, and looked to me like he had like almost like a 5 o'clock shadow. White gentleman.
If you saw that person again, do you think you'd be able to recognize him?
Yes, sir.
Do you see that person seated here in this courtroom today?
Yes, sir.
Could you point him out and describe where he's sitting and what he's wearing?
Light blue, light color shirt with the tie, right here.
Your Honor, may the record reflect that the witness has identified the defendant, Donald Smith.
The record will so reflect.
Did you find it odd that the defendant had made this comment to you?
Yes. I didn't know who he was or why he was there. My first recollection was, is my father in this van? Why is he trying to talk to us now?
Could you tell if there was anybody else in the van with the defendant?
There appeared to be someone in the front seat. I don't know who or what, but yes, there was something in the front seat. I could tell shadow for sure.
How long was this interaction when he says this comment about going for cheeseburgers before the van actually pulls off?
It was a very quick exchange, almost like we had been friends forever, and I was very confused. Maybe less than a minute.
Did you see which direction the van drove off in?
Very clearly, yes. Where we were sitting, he actually pulled around the corner and went towards, I guess, where the semis would exit and where the stoplight was, not where the stop light, but the stop sign, and turned towards the right.
After the van drove off, did you wonder whether or not your father was actually in the van?
Yes, because it usually, if I have baby with us, we would always go sit down and have something to eat, or at least grab a French fry or something. So going to have cheeseburgers or going to even get a Frosty was a very normal occurrence for us.
Did you and your husband and your daughter decide to then follow after and see if you could catch up to the van?
Yes, we did.
Did you drive down towards where the McDonald's was on Lem Turner?
And we circled the parking lot to make sure the van wasn't there.
Did you ever see the van?
Not once it left and turned right, no.
Did you ever see this defendant again?
Not till today.
Did you go to another restaurant in case they didn't mean McDonald's, they meant someplace else?
Yes, actually, we went back around the McDonald's because there's an entrance here. We went around the McDonald's, came back up after the light turned green, went through next to the bank in the Home Depot, and went to the Wendy's, and we circled the Wendy's parking lot before returning to Walmart.
When you circled the
Welcome back to the Law&Crime Network. We just threw to that clip, which seems a little bit random, but Andell, I wanted to talk to you about her, what seemed to me to be theatrics. You know, she was very expressive, very wanted to show where things were, and then especially when it came time for the identification, she was asked to identify the defendant, and she looked to her right where there's no people sitting and looked all over the room. Does this sometimes sort of recognize risk of trying cases where you have to call lay witnesses that they may overact when they're testifying?
You know, that's always a concern because everyone watches a lot of television and they watch the Law and Orders, et cetera, and they're waiting for their moment on the stand. Unfortunately, regular everyday court is not as dramatic as it is on television, but Ashley would not be determined. Ashley Chappelle said, "This is my moment in the spotlight. I'm going to take it and I'm going to milk it for everything it's worth." I think she's telling the truth. I think her testimony is reliable, but come on, Ashley, you're being a little bit extra with the look to the right and the look to the left. Where is he? Maybe it's the guy sitting between the two lawyers at the table. Maybe that's who you're looking for. And that's what she ultimately identified.
Ashley was definitely a little bit extra. She definitely, I mean, the thing about these types of lay witnesses is for them, there's no risk. They know that they can't get in trouble. They're not, you know, their jobs aren't at risk. There's no money at risk. Their freedom isn't at risk. They're not as invested as the people who are related to the victim. And so for them, as you said, sometimes it's just sort of a moment in the spotlight. I do want to go back. You and I had been talking a little bit about the defense's plan and their strategy here, and this is yet another witness where there actually was cross-examination of her that I just don't understand how it, you know, when I prepare to try a case, I prepare a story, and I almost, see it as a movie, step by step by step by step, and where do I want the jury to come at the end? What's the finale? I cannot figure out the story that the defense attorney and the defendant is trying to tell in this case. And I don't see where the cross-examination of our friend Ashley led to that. Can you, with me, watch this clip, Andell, and then help me try to figure out maybe where this defense attorney and the defendants are going?
I'll do my best.
All right, let's play. It's a quick one. Let's play this quick clip.
Okay.
Good afternoon.
Good afternoon.
You ended up having to wait there for trying to connect with your dad for quite a while, correct?
Yes, ma'am.
Long enough for the security guard that travels around the parking lot to come around and check on you 3 or 4 times?
At least twice that I remember.
Okay. And it was an odd occurrence, correct?
Very.
I mean, this person drives up close enough to where his passenger or his driver's side window is right next to your passenger window.
No, that was my husband's passenger window, but my car, yes.
Right, I apologize, you were driving. But close enough to where each of you were able to get a good enough look at him to identify him?
Yes.
Okay. And the statement was, we're going to get cheeseburgers.
Yes, ma'am.
Okay. And do you remember anything else that was said?
No, ma'am.
Okay. Could it also have included the statement, follow us?
It's possible.
Okay.
It's been a while. I don't remember exactly what was said.
Regardless of exactly what was said, you all did attempt to follow them.
Yes, ma'am.
Okay, and you went to a McDonald's location that I guess you were familiar with the area?
Yes, ma'am. It's right up the road.
Okay, and then you also even circled back to Wendy's?
Yes, ma'am.
Okay, all right, I don't have anything further.
So
Thank you.
Andell, there you go. That's the cross-examination of her, relatively short, wasn't much longer than what we just showed. Where do you think the defense is going here?
Well, taking from the defense opening, which was also very short, it appears that they're trying to inject some type of confusion as far as what happened when the van left the Walmart and going to get burgers, and there happened to be a McDonald's that was open 2 miles down the road, not the one in the Walmart. But I really don't know where that leads us. I think one of the things you mentioned, Heather, is that in your case, in your defense, you kind of want to move in a very focused direction and not go off on tangents. We call that the theory of defense. You don't ask a question or you don't explore something that has nothing to do with your theory of defense. It's irrelevant. So I don't know what the theory is because it seems like they're a little bit all over the place and they're just kind of reaching for straws to help them somehow emerge from this case without Donald Smith getting the death penalty. I don't think there's anything they can say or do to overcome guilt beyond a reasonable doubt. But their strategy seems very convoluted and unclear right now.
Yeah, it's just convoluted and unclear is right. You know, you try so hard to sort of imagine what it is that they're saying and what it is they're trying to put together here. Again, our trial producer Kathy Russin pointed out that that couple, Ashley and her husband, were in a gold car, and Donald Smith had told Rain Periwinkle, Cherish's mother, and Cherish, that his wife was coming in a gold car. So perhaps him pulling over and saying, we're going to get hamburgers and maybe even follow us, was meant to reassure Cherish that this was this woman. Even if that's true, and that's a great premise by Kathy, I don't see how it furthers the defense. And it's frustrating to me because I'm just wondering why they're even doing any cross-examination. Because let's make this clear, Andell. If you want to, the burden of proof is not on you as the defendant. You don't have to examine anyone, do you?
You absolutely don't, and that's one of the things we even discuss in jury selection when we're discussing the burden of proof. We say, hey, as a defense, we can sit here at the table and do crossword puzzles the entire time and never ask a single question of a single witness. And unless the state has met their burden, you don't have reasonable doubt. That's something we emphasize. In this case, I find it especially odd that they do not cross-examine Rain Periwinkle, but then they decide to cross-examine Ashley Chappelle, who seems to be talking about an issue that is either a tangential issue, it's kind of on the side, it's not the main issue, or the issue is something that actually hurts them instead of helps them. It makes it seem like Donald Smith is being deceptive and manipulative. I don't think that's the way you want the jury to look at your client.
That's it. I mean, it's just, I am shaking my head because, you know, this defense attorney has been doing this for long enough, and it's not just her team, that it's not, you know, I think you and I have even talked about this before, Andell. As a young lawyer, sometimes you just speak because you're supposed to speak as a lawyer, and you examine because you're supposed to examine as a lawyer, and you don't realize that sometimes it's better just to keep your mouth shut. But you'd think with some experience, this team would know when it's better to keep their mouth shut, unless, as you said, it's the defendant driving the bus.
I think that may be the case, and I think it's also they're in that unenviable position where you don't really have much of a defense.
Right.
But you got to do something, right? You're his lawyer. You got to defend him. But it's like, okay, where does the defense come from? I think one of the things that the defense team, surprisingly to me, did not do was get more in depth as to what's going on with Rain Periwinkle and this story. When we listen to the 911 tape, when we listen to her testimony, and even when we watch her on the stand, there are a couple of things that seem a little abnormal that a normal parent in that situation would not do, that you could investigate, that you can kind of use to figure out, is there something more going on here? But they declined to do that, and now they're asking random questions from other witnesses that have nothing to do with the heart of the case.
Yeah, it is definitely befuddling for sure. The state is in their case in chief, so we're still in the prosecution case. They have 5 witnesses left on their list, and they may not call all of them. The next 3 on the list, Andell, are from jail recordings, so jailhouse snitches that we sometimes see. Do you think at this stage of the trial, where you've got the cross-examinations being brief, if anything, the defense opening really being a lead balloon given what happened immediately thereafter, and now the medical examiner's testimony being so strong and so effective, do you think the state at some point can maybe pull back on all of the witnesses that they were going to call and rest so that the jury can get to the point where they're actually being able to enter their verdict?
I wouldn't think the state would do that. I think it would be very important to make sure that they have proven every element of this case beyond and to the exclusion of a reasonable doubt. And I think they should call all the witnesses that help do that, help reinforce and strengthen the case. I don't think you should ever walk into the trial with a mindset of saying, you know what, I think I've done enough, I'm going to take it easy. You cross every T and you dot every I. That's what I would expect them to do here.
Ladies and gentlemen, Andell Brown, that's the kind of attorney you want, is someone who's going to cross every T and dot every I. I couldn't agree with you more. You want to bring everyone in. But I do wonder, Andell, and help me out with this, when it comes to these snitches and their testimony, we often see that type of thing as an issue on appeal. How do you weigh that? How do you weigh, if there's been a lot of motions in limine about a particular witness, motions in limine means trying to keep out particular witnesses with legal motions, and now you've got this witness that may help your case but doesn't put the cherry on top. Do you still use that witness when you know it could lead to an appellate issue in the long run?
Well, I think if you look at the case as a whole, even if this witness became an issue, the appellate court would look at the entire case and all of the evidence, and they would say, let's say this witness was so unreliable, they were coerced, the state promised him the world in order to come and testify, and everything he's saying is a lie. Let's say that is true. Now, would that, when we look at the other evidence in the case, which appears to be pretty strong, mean that he couldn't get a fair trial? I don't think that one factor would be able to overturn this case. If that witness's testimony was what this case relied upon and it turned out to be fraudulent or gotten in the wrong way, then it probably would overturn it. But in a case like this where you have DNA, you have forensic evidence, you have video evidence, you have testimony, you have the circumstantial evidence, and all of it is so strong, I don't think that particular witness is going to turn this case one way or the other. I think the state is looking at the fact that now not only do we have all of this evidence, we have a confession. We have his own words. We have his state of mind. And I think what the state is looking at is for the death penalty phase to show that his crime was intentional, it was calculated, and he has no remorse for what he's done.
Yeah, I couldn't agree with you more, and I think that that's why these pieces of evidence that are about to come in after the lunch break, or at least we anticipate so, are so important, because the prosecution has done a great job in establishing motive and in establishing really that he was hunting Cherish Periwinkle. Yesterday, I don't know if you caught it, Andell, but for a long time yesterday afternoon, we watched the video of the dollar store and then the Walmart, and they had put the FBI expert who was testifying had placed arrows above the heads of Donald Smith, Rain Periwinkle, and Cherish Periwinkle, and it was so effective in showing how he was sort of circling the situation and spending time with the mother and then with Cherish, and Cherish would wander off and he'd go find her, and it almost looked as though he was stalking her. This one arrow was so ominous and scary, and that, I think, is going to be very effective in showing intent when the prosecutor gets up to argue their closing. Have you ever used something like a video in that way so that it really effectively tells a story with no words?
I think video is one of the best tools in communicating with juries, especially because they get to see it. And at the close of the case, they're going to be able to take it back and look at it again and again and again. Another reason is that it's objective. Everyone is going to look at it. They can see what it is. There's really no argument about what the video shows. Look at these arrows. These arrows are following them throughout the store, and I think it just makes it clear as if he's circling his prey, looking for his opportunity. It makes it look like he premeditated this, he planned it, and when he saw his opportunity, he went in for the kill.
Yeah, it's extremely effective. Maybe one of the most effective uses of video that I have seen. The other piece of the death penalty and his planning this out and all of these things that we've talked about a little bit, and I'd like to get your thoughts on it, Andell, is, you know, this man has a long history of this type of behavior. In the late 70s, he was arrested for lewd behavior, and then he had been arrested and gone to jail on 2 other occasions, and in fact had only been let out about 21 days prior to Cherish's murder. And yet, in our legal system, that's information that for the most part will not be admitted. The only way that I can think of is for that information to get in before this jury is if Donald Smith testifies. Can you think of any other way in this case that the prosecutor could get his priors in before the jury?
I think the only way that would come in, Heather, was if it showed a specific modus operandi or way of operating. Just the fact that he's had other cases that may involve similar allegations, I don't think is enough. However, if the prosecution can show and overcome the legal standard that the way he did this, there's something special about the way he did this that points to him specifically and not just in general, I think they could overcome it. Furthermore, in this case, I really don't think they need to, and I think it's good that our law protects cases from undue influence, from information that's either irrelevant or prejudicial, because you don't want juries convicting people just because they're saying, well, this is the type of person that may have done something like this in the past, so without providing evidence that he did this particular crime, we're going to convict him. That would be wrong, and that would be unjust. I like the law the way that it is, and I think that the prosecution can get it in if they can show it's a special, particular way that he does things.
Yeah, and I don't think that that's going to happen in the guilt phase. But in the death penalty phase, it's going to be interesting to see the dance around that, don't you think? Because you know the defense is going to have, well, you would assume, you never know with this case, you would assume the defense would be putting forth some sort of testimony to say that he's an okay guy and for some sort of mitigation for reasons not to kill him. But as soon as they open the door to that type of testimony, doesn't it become a little bit more likely that the prosecution will have an argument to get that in?
Yeah, I think at the penalty phase, it's fair game at that point. Once the jury has decided that he is guilty of those charges, at the penalty phase, now they're just looking at whether or not his actions, his intent, his mindset, and his history determine that he should be given the death penalty. Because, of course, as you said, Heather, the defense is going to bring up all the things that happened in the past that either should mitigate, they're going to talk about his childhood, whatever abuse or trauma or psychological profile he has that brought him to this point. And it would only be fair that the prosecution can rebut that with evidence of other things that he's done in the past.
Yeah, this case is, the defense attorney's real job is going to come at the death penalty phase of this case, because with the DNA evidence that we just heard, where the DNA expert pretty much said that this is an exact match. I mean, she's talking about 12 zeros, one in that many quadrillion would have been this type of a match. That's a pretty exact match. But before we got to the DNA testimony, we heard from the medical examiner, and this particular medical examiner was definitely invested in the case, Andell. I want to play a clip of the medical examiner and then talk to you a little bit about how effective that type of testimony is in compelling the jury to come to a certain decision, and how effective you think it will be in this case. So let's hear from her a little bit this afternoon.
You mentioned that in this particular case, you conducted the autopsy the day after Cherish's body was transported to your office. Is that correct?
Yes.
On what day was that?
So the date of the autopsy was the 23rd, and the sex battery kit was done on the 22nd of June, 2013.
Did you determine the weight of Cherish Periwinkle?
Yes.
And what was that?
She was 67 pounds.
May I approach the witness?
You may.
Dr. Rao, let me show you a set of photographs that have been marked in alpha order, triple B through quadruple V as in Victor. Have you reviewed these photographs prior to your testimony today? Did you review these photographs prior to your testimony today?
Yes,
And in fact, are each of these photographs that were taken at your direction?
yes,
This time I would tender into evidence what has been pre-marked for identification from states triple B to states quadruple B.
That will be noted for the record. Triple B will be entered as States Exhibit 54, Triple C 55, Triple D 56, Triple E 57, Triple F 58, Triple G 59, Triple H 60, Triple I 61, Triple J 62, Triple K 63, Triple L 64, Triple M 65, Triple N 66, Triple O 67, Triple P 68, Triple Q 69, and Triple R 70, Triple S 71, Triple T 72, Triple U 73, Triple V 74, Triple W 75, Triple X 76. Is there a Triple Y? Or we're not there on that one yet? There is? Okay, Triple Y is 77, Triple Z is 78. Quadruple. Oh, okay, so that, I need to go back then and not mark Triple Y. And Triple Z will be number 77 in evidence, correct? Correct. And Quadruple A is 78, and Quadruple B is 79, all in evidence.
Okay, Dr. Rao, let me direct your attention to your screen, please. Do you always take a photograph of the face of the body that you are working on, reflecting the medical examiner number assigned to the body?
yes.
Let me direct your attention to what's been introduced into evidence. It states 54. Does this photograph, in fact, reflect the medical examiner case number assigned to Cherish Periwinkle?
Yes, so 13-1034 means that in the year 2013, she was the 1034th case that came to the medical examiner's office.
Dr. Rao, you mentioned that the body was washed after arrived to your office, was her hair also cut?
Yes.
And for what reason?
So during the autopsy, when the scalp was reflected, there was an area of hemorrhage in her scalp that couldn't be seen because the hair masks the injuries on the scalp. So I shaved her entire head so that if there was a pattern on her scalp, we would be able to see that and photograph it.
Okay, next, I'm going to, as we go through your photographs, I'm going to first highlight for the jury what to expect. This next series of photographs, Dr. Rao, are as to injuries, superficial injuries to Cherish Periwinkle's body. Let me direct your attention to what's been introduced into evidence as States 55. Will you please explain to the jury what is reflected in this photograph?
Okay, so what you're looking at are two areas of injury. There is one right here, and there is another one right there. So the contrast between the two, what you are looking at in this area is post-mortem ant activity. The ants bite the bodies, anything that stays there, and she was in this wooded area. So there were a lot of ants there. So after death, that's why you have that very different color that's yellow, dried, and parchment-like. Whereas this area, you can't really see her nipple because she's very light-skinned and it kind of blends with the rest of her chest area. But you can definitely see this is where her nipple is, and she has bruising right there that is caused prior to death while she was alive.
And do you have an opinion as to that injury?
Yes.
Let me show you what's been introduced and marked as States Exhibit 56. Is this in fact a close-up of the right nipple of Cherish Periwinkle?
Yes. So just to tell you, this is where her nipple and areola, the brown area surrounding the nipple is. And around that you can see the bruising, the pink-blue discoloration.
Dr. Rao, what is your opinion as to that injury?
That is consistent with somebody sucking on her breast.
Let me direct your attention to what's been marked as introduced into evidence as States Exhibit 57. Will you orient the jury to this photograph, please, and explain the injuries reflected in it?
Yes. So this is her left leg. This is the knee area right here, so you can orient which part of the body. You have bruising right here. You have bruising right here, and you have a scratch here, a small bruise there.
What were you able to determine as to when, in relation to death, Cherish sustained these injuries?
All her injuries that she sustained are prior to her death, consistent with that time frame.
Let me direct your attention to photograph 58. Will you please explain what's reflected in this photograph?
So she has an injury right here. She has an injury right there. Smaller bruises right there.
States 59, will you explain to the jury what this photograph is of?
Okay, so you're looking at the back of her left leg, and she has a bruise right there. This is the back of her knee, so to orient you, back of her knee, and this is where her buttock area is right there. She has a bruise on the back of her left thigh.
State 60, will you please explain to the jury what this photograph reflects?
Yes, so this is her right leg. To orient you, this is her knee, her right knee. She has a scratch right there. She has a scratch right there.
Welcome back to the Law&Crime Network. I'm Heather Hansen, and we're watching the testimony of the medical examiner, Dr. Rao, in the case against Donald Smith. Andell, we were just talking briefly off air. This testimony is awfully hard to watch, isn't it?
It certainly is. I mean, it is so graphic and detailed, and it just gives you the brutal experience that Cherish Periwinkle went through in those hours leading up to her death, I mean, it is difficult to listen to. And even the medical examiner, you could see that it's difficult for her to go through some of these details.
And you've led me to my next question. We're going to play another clip in just a minute where she actually breaks down. Now, in all of your years defending criminal cases, I'm sure that you've had to cross-examine or examine medical examiners. Have you ever seen one break down in tears?
Never. The medical examiners tend to be very clinical in their approach. It's all about the facts. It's all about, just doing the examination and what the examination reveals. They try to avoid making any type of conclusions or legal arguments from one side or the other. They're really just about the facts. And to think that someone who for a living has to look at many people that have passed and examine the bodies, you have to think about how thick your skin has to be to do that for a living, then to break down crying, testifying about what they're going through. It had to be a very extreme situation and had to have affected her very deeply.
Yeah, and we're going to go step by step through her testimony because she continues to hold tough. I think one of the ways, I've talked to some medical examiners and doctors who do this type of work, and they say that the way that they're able to do it is to some degree depersonalization. They have a lot of respect for the body, but they don't think of the body as a living, breathing here little girl. And you can almost see Dr. Rao in that last clip sort of trying to get back to the specifics of what she's testifying to instead of putting it in the big picture. Do you think that becomes harder once you're in the courtroom where you're talking about someone who's a young girl who's been killed?
I think it can, especially if, the other testimony is as it proceeds. I'm assuming they've invoked the rule of sequestration so that she's not hearing the testimony of the other witnesses. But being there on that day and knowing why you're there, I think has to have a very great effect on the individual. But still, medical examiners are professionals. They do this all of the time. For the case to affect her this way to the point where she's displaying emotions, I think means it just kind of goes into the egregious nature of what happened here.
Yeah, and it's just, it's mind-boggling what this man did to this girl. And I do think the prosecutor has done, the prosecution team, there's a number of them, have done a fabulous job with their order of witnesses. Andell, you and I have talked about this before, but it's not as easy as it looks to make sure that your case goes out to the jury in a way that flows very well. And here they called Rain Periwinkle first, and then sort of went step by step through the dollar store, and then the Walmart, and then the parking lot, and Ashley, who we saw just a little bit ago, and then the people who discovered the body, and then the body itself, and then after the medical examiner, we heard from the DNA expert. How much work does it take to make sure that your story can go in the order that you want it to?
Well, it's all about preparation, Heather, and that's where trials tend to be won or lost before it even begins, is in the preparation. From the opening statement that the prosecution gave here, I thought they did an excellent job of capturing the story, making sure the jury understood the demands of justice, and explaining to the jury how they would fulfill their obligation to provide evidence beyond and to the exclusion of a reasonable doubt. I think they did a great job of doing that, and their preparation continues to show throughout the trial in the flow of the witnesses, the order that they're doing things, and it kind of is in stark contrast to what we've seen from the defense team as far as them kind of being all over the place. The prosecution seems to be right on the money here. They're really focused on what they're going after, and they're laying out their case for a conviction and for the death penalty step by step.
And doesn't it also show the support of the community? Because you can lay out your case as well as you like, but if you can't get people to come in and testify on the days that you need them to testify, you can't control that. And yet here, the fact that the DNA expert was able to come in right after the medical examiner, right after the FBI expert, that takes the cooperation of these witnesses and shows perhaps the investment that all of those people had in making sure that a conviction was received here.
Absolutely. And to totally transparent. Many of the prosecution's offices, they have victim and witness coordinators who handle a lot of those things for them to make sure that people are coming in on time. If they don't have transportation, they're going to get them there. They follow up and they call those people. But overall, when it comes to the presentation to the jury, having your witnesses in order and having the order kind of flow into your theory and your argument in the case really makes a big difference. Juries love it when lawyers are prepared, when they're succinct, they get to the point, and they don't waste their time. And I think that's what the prosecution has done here, and it's making them look good.
Yeah, without a doubt. I want to continue with the medical examiner testimony, as difficult as that is to see and hear. It is in many ways the crux of the case, and certainly, as Andell has pointed out, will be a big part of what the jury brings to them if and probably when they get to the death penalty phase because of the egregious, terrible nature of these crimes. So let's watch some more of Dr. Rao testifying, and we'll be back with Andell in just a minute.